Mr. Noey was previously in court in cause numbers 25 DCCR 0386 and 0387, entered pleas of guilty to intoxication, manslaughter, as well as driving while intoxicated with a child less than 15 years old. That was an open plea to the court. We had gotten started a little bit on this hearing, and then I reset it so that the state could, or anybody could, bring any witnesses with regard to statements in the PSI and sentencing. We've all had an opportunity, correct, to review the PSI.
State has, Your Honor. Yes, Your Honor.
Other than what we've already discussed and what the defense has filed with regard to response and objections, anything else with regard to the pre-sentence report?
Not from the state. Not at this time, Your Honor.
Okay. There was also a letter from Joyce Barnes, the mother of the defendant, and I have that as well.
Your Honor, I think we had also previously filed letters of support, which the court had reviewed.
Okay.
Yeah, the state calls Trooper Angel Campos.
Trooper Campos?
Oh, yeah. Trooper Campos, how are you employed, sir?
I'm employed to the Texas Department of Public Safety.
And how long have you been with DPS?
I've been with DPS today almost 3 years.
Okay. Your training and background, of course, includes the academy. I understand you also have some military background as well. What does that include?
I do. I'm working on my 11th year serving in the Marine Corps, and currently I'm a Staff Sergeant E6 in the Marine Corps today.
Okay. Describe for the judge what you observed when you made the scene.
Initially, when I made scene, I was expecting, like I was dispatched to 2 vehicles. Then I later found out the 2 vehicles that I rode up on, one was the deceased's vehicle, and the other one was the witness that witnessed the entire crash. I didn't see a third, but I couldn't really comprehend what had happened because I couldn't find the car that did everything. And then I later found out through on-scene personnel that the vehicle that caused the crash was further down the road, upside down.
Did you make contact with the driver or the operator of that vehicle?
I did.
And was he identified?
He was.
Who was he identified to be?
Anthony Noey.
Okay. Investigation, did you determine if that child was restrained in that vehicle during the crash?
Yeah, the investigation determined the child was not restrained at the time.
When you made contact with this defendant, we're not going to spend a lot of time on it because he's already pleaded guilty, but nevertheless, you observed signs of intoxication, correct?
Yes.
Did he refuse or did he consent to a blood draw?
He refused.
And you obtained a blood search warrant, correct?
I did.
And his blood was drawn pursuant to that blood search warrant.
Yes.
What I'd like to ask you about next and explain to the court is this defendant's demeanor. How would you characterize this defendant's demeanor there at the scene and at the hospital as well?
So his demeanor.
Your Honor, I'm going to object to this to the extent that he's required to. I don't have an objection to him observing what his observation, but to the extent he's going to opine, we're going to renew our objections that we've already made in our response to objections.
That's overruled. He can testify as to what your opinion is as to his demeanor that evening.
Please go ahead and answer. True.
The demeanor on that night, he refused to comply with almost every order we gave him. We had tremendous amounts of patience to try and do our job, and he made it every bit difficult, to include the omittance of, allowing us to prove. I even asked him on scene if he could let me do centralized field sobriety test so we can rule out his intoxication, and he refused that too. Tried to give him a chance there, tried to give him a chance to consent blood, and he refused there too. Did every trick. Well, it appeared like he was trying to buy time for himself, and he, through my training and experience, we kind of pick up on tricks that DWIs do, and it appeared like he was utilizing everyone he could at the time.
Now, and I'm sorry to interrupt, but we're talking about more than just a refusal or more than just not cooperating, correct?
Yes.
I mean, how would you describe that to the judge?
I would object to leading on that one, Your Honor.
Overruled. Go ahead.
Everything on that night, he, from what I can recall and remember, everything he mentioned or asked, none of it was about the other parties. It was all either about himself or his son.
In your interaction with the defendant that night, you'd already informed him that someone had died as a result of that accident, correct?
I did.
Before you informed him, and even after, did he ask or inquire of you what happened to the other individual or individuals involved in the accident?
Not that I can recall, no.
Is it fair to say that his focus was just on himself throughout your entire interaction with him?
Yes.
As to what he's jumped in.
Thank you, Mr. Coleman. Mr. Franklin?
I have no questions for this witness, Your Honor.
All right. Any objection to Trooper Campos being excused?
No, yeah.
None, Your Honor.
Thank you, sir. You're excused.
Yes, Your Honor.
It has no further witnesses in the state arrest, Judge.
All right. Thank you. Any witnesses, Mr. Franklin?
I have advised my client about his constitutional rights to testify or not testify. I have advised him against taking the stand. He's decided not to take the stand. I just want to make sure that we put it on the record that he has been advised and he has chosen not to take the stand, Your Honor, and testify. I would like to offer closing.
All right. Thank you.
On testify.
And so, Mr. Noey, you have every right to testify if you would like. Obviously, you've already pled guilty, so there's not an issue with regard to, whether you did it or not. There's been a plea of guilty. If you've talked with your attorney and it's your decision not to testify, is that correct?
I just wanted to apologize, ma'am.
All right. That's good. Thank you. If you want to testify, you can get up on the stand because you'll be subject to cross-examination. So you can't just make a statement to me. If you want to get up on the stand, I'll swear you in and then the attorneys can question you.
No, Your Honor.
Okay. All right.
I want to comment a little bit on the evidence from Trooper Campos.
Sure.
And point out that some of the language used by him about the worst case, et cetera, he just testified he's been with DPS for 3 years. He would have been with them around a year at the time. What the evidence actually showed was Mr. Noey saying please and yes, sir, that he wanted his son to be okay. It was really only in the last video that he had finally learned that he testified that Mr. Johnson had passed away in this case. There's no testimony about him having any knowledge of that in the prior videos. Part of the statements about the reprehensible nature of my client's actions, about how he was belligerent and reckless, I'm not sure that any of the evidence produced by the state, particularly on the scale of belligerent and reckless defendants, actually rises to that level, and nor is his decision to exercise constitutional rights belligerent or reckless. Otherwise, our arguments have been in our written motion, Your Honor, and we've presented information to the court, including the letter from his mother, the letters of support, and the information about his sobriety since the accident. Put the defendant on probation, Your Honor.
Thank you, Mr. Franklin.
Just to hit the high points, Your Honor, this defendant's blood alcohol was a 0.149. He had his son, a child passenger in the vehicle, while he was driving at a 0.149. And that child, his son, who in the video he professed that he cared so much about, was not restrained by a seatbelt. Judge, we have a situation here, but for the grace of God, that his son didn't die, and that more people on the roadway that evening did not die. I think what's aggravating in this case, and I attached a copy of the SAFP paperwork to my sentencing memorandum, is that this defendant, as part of a probation for felony possession of marijuana back in 2013, was assessed 7 months of SAFP. And I would think that after 7 months of SAFP, he would have addressed what, if any, substance abuse issues that he may have had, that including alcohol. And I find that him finding himself in this situation, a more egregious situation, could have been avoided had he taken full advantage of the rehabilitative effect of SAFP, Judge. Mr. Johnson, the victim in this case, Douglas Johnson, got a death sentence, unfortunately, that day, Judge. And I think justice in this case would not lend itself to this defendant walking out of this courtroom today on probation. I think justice in this case would be for this defendant to spend some time in prison.
Mr. No, these are some extremely difficult cases. When someone loses their life because of your actions. And Mr. Franklin made the arguments and did a great job with his memorandum to the court, trying to point out things and make me think about things in a certain light. Obviously, you didn't get in a vehicle with the intention to kill someone that night, but you did get in the vehicle knowing you were intoxicated with your 9-year-old son, and you ended up killing someone. He also made an argument about that SAFP and some of that documentation and the fact that you'd been was old, and I shouldn't take that into consideration. I think it's very relevant, though, that you have been through treatment. Even though it's been a while, you obviously had some issues, went through treatment, a serious treatment program where you're in custody in treatment. So you have felt what it's been like to be in custody and still committed this offense. I don't think probation is appropriate in this case or either case. I'm going to find in cause number 25 DCCR 0386. Again, you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0387, also find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of driving while intoxicated with a child passenger, sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you were in custody that the law gives you the right to receive. I'm going to hand you in each of your cases or to your attorney. He'll give it to you, the trial court certifications that shows these weren't agreements. You do have some limited rights to appeal, and you could talk to Mr. Franklin about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can also talk to Mr. Franklin. Mr. Franklin, if you'll grab those for your client. Thank you to the troopers for being here, and court will be adjourned.
Ray Anthony Noey stood before the court after entering an open guilty plea to 2 charges: intoxication manslaughter and driving while intoxicated with a child passenger under 15. The facts of this case are as devastating as they are preventable. Noey got behind the wheel while intoxicated, with a blood alcohol level of 0.149, nearly twice the legal limit. His 9-year-old son was in that vehicle, unrestrained by a seatbelt, and on that night, Douglas Johnson lost his life. When Trooper Campos arrived on scene, the wreckage told a grim story. 2 vehicles were visible, one belonging to the deceased, the other to a witness. The car responsible for all of it was found further down the road, flipped upside down. When officers made contact with Noey, he refused field sobriety tests, refused a consensual blood draw, and had to be compelled through a search warrant. According to the trooper's testimony, throughout every interaction that night, Noey never once asked about the other people involved in the crash. His focus remained entirely on himself and his son. What makes this case even harder to absorb is that Noey had already been through a serious substance abuse treatment program, 7 months of SAFP as part of a prior felony probation back in 2013. He knew what addiction looked like. He had been given tools to address it, and yet here he was again, under far worse circumstances. The judge rejected probation. Noey was sentenced to 15 years in prison for intoxication, manslaughter, and an additional 2 years in state jail for the DWI with a child passenger. Well, Douglas Johnson received a death sentence on that roadway, and the court made sure accountability followed. Some second chances are squandered in ways that can never be undone. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.